It's great to welcome to the program today Kade Crockford, who's the director of the Technology for Liberty program at the ACLU of Massachusetts. Kade, great to have you on. I appreciate it.
Thanks for having me.
So I want to talk about biometric surveillance, facial recognition, and how law enforcement may or can use these technologies. But first, recently on the program, I had someone call in and talk about, hey, David, hasn't what we mean by a right to privacy been drastically altered by the technologies that exist today, in the sense that 100 years ago in public, legally, you might have had a very similar a set of rights and laws as you have today. But in practice, a lot of the technologies that exist today and didn't 100 years ago have changed what it means to be anonymous or to be in private or in public. What should our understanding of this be under the law, but then also kind of a more colloquial understanding?
That's a great question. People need to remember that in a democracy, and our society is ostensibly a democracy, we, the people, are in charge, not corporations or government agencies like the FBI. So we have the power, at least theoretically, to determine how new technologies ought to impact our right to privacy, to anonymity, even in public space. So I just want to remind folks that the Constitution, the way that it's interpreted by the courts, is merely a floor. It is not a ceiling. So in other words, we could certainly, if we wanted to, pass laws prohibiting corporations from selling our cell site location information. That's the information revealing where we've been, where we've traveled with our cell phones in the past. We could do that. It just requires a political will. We certainly could prohibit or severely restrict the government from using technologies like facial recognition in public space. That's merely a political problem. It's not a technological problem. So certainly technology has changed the degree to which both corporations and governments can create really comprehensive records of our movements, our activities, our associations, our interests. But that's not necessarily inevitable. It is merely because we have not taken the necessary political steps to ensure that our technology does not outpace the law with respect to our privacy protections.
And when we start to look at the ways in which law enforcement use or utilize some of these technologies, we've talked about everything from I believe they're called Stingray, a cell tower, sort of replicators. I may be lacking the exact right vocabulary, but the idea that the police can have a device that your cell phone will believe is just another cell tower and connect to it. And by virtue of that, you are passing a lot of information on to law enforcement, biometric surveillance, facial recognition software. We're going to get into some of these specifics and where they're being used, but what is the position of the ACLU, generally speaking, about law enforcement's ability to use these different technologies when a warrant does not exist for the specific surveillance of an individual?
So just as a general matter, the Fourth Amendment provides for our right to privacy and says essentially that unless you're involved in criminal activity and the government can show evidence of that, which is called probable cause, to a judge and get a warrant, they shouldn't be able to invade your privacy. Now, as we kind of discussed before, there's an active debate about what privacy means in the 21st century. So just as an example, a recent Supreme Court case that was decided in the summer of 2018, last summer, called Carpenter versus United States, is the most important privacy ruling we've seen at the Supreme Court in a long time. And that case is particularly important because it disagreed with law enforcement's interpretation of the Fourth Amendment, which essentially was that when you go out in public, you have no right to privacy. So the court held in a very important ruling, in the Carpenter ruling, in a decision written by Chief Justice Roberts, that in fact, technology has substantially changed the balance of power between the government and the people. Now, in a free society, in a democracy, the government ought to know almost nothing about the general population unless we've affirmatively disclosed information to the government to receive benefits or something like that. And we should know almost everything about what the government is doing. new surveillance technologies, and unfortunately the post 9/11 hysteria around terrorism has really flipped that balance. So now the government, and this is true of even local and state police officers, all the way up to the level of the federal government at the FBI and the DEA, et cetera, they can know almost everything about us, often without a warrant. And we know very little about what they're doing because their operations are shrouded in secrecy. So the Carpenter ruling is really important because it stakes a very clear claim, or rather draws a line in the sand for 21st century forms of surveillance by essentially saying it is vastly different for law enforcement to use technology like cell phone tracking, technologies like cell site location information that is maintained on hundreds of millions of people across the United States. That is qualitatively and quantitatively different from law enforcement following one person around to see where they're going. And this is an important concept that we call friction, right? There are only so many police officers in the US. I think there are too many. There are about 1 million. But there are over 300 million people in this country, right? And so it would be physically impossible for law enforcement to follow each one of us around, noting our every movement every day of our lives. Cell phone technology makes it possible not only for law enforcement to see where we are in the present moment and on a mass scale, but also to do something that was previously impossible, which is to find out where we were 3 weeks ago, 3 months ago, 6 months ago, before we were even under a criminal investigation or suspected of a crime. And so Chief Justice Roberts says that because the technology facilitates a new form of mass tracking that is not possible without the technology, the government is required to get a warrant, even if they are merely tracking our public movements, even if they're not tracking our private movements in our home, even if they're just tracking where we go on public streets, because previous to the existence of this technology, that type of surveillance was actually not even feasible. So yes, mass surveillance is distinct from individualized, targeted surveillance that law enforcement is engaged in because they believe that someone is actually engaged in a crime. New technologies, license plate readers, face surveillance technology, certainly cell phone tracking, give the government the power to very cheaply conduct surveillance of hundreds of millions of people's movements and activities. And again, not just in the present moment, but actually reversing back in time to see what we've been doing days, weeks, or months before.
So let's now dig in a little bit to the specifics of how some of these technologies are being implemented. Different types of biometric surveillance and facial recognition. Where is it currently being used?
So there's a lot we don't know, unfortunately, especially about what the federal government is doing with face surveillance technology. Remote biometric tracking technologies we view as distinct from the traditional forms of biometric surveillance that the government has conducted, including fingerprints and DNA. Right. And the reason that iris scanning, gait scanning, so that's the way that you walk, is also a biometric, which just means something that's unique to each individual. Of course, our faces, there's even some science that says the shape of our ears is a biometric. So these new forms of biometrics that the FBI has been experimenting with for years now, and that state and local law enforcement are beginning to use to track and identify people, those are distinct from fingerprints and DNA for one simple reason. And we need to think of them as a class as uniquely dangerous for this reason. It is necessary, again, this is back to the concept of friction. If law enforcement wants to get my fingerprints or my DNA, they actually have to send someone physically to follow me, to pick up my coffee cup or my cigarette butt when I've thrown it on the ground or in the trash, to test that material, that physical material. It is not possible yet, maybe it will be someday, but it's not possible yet to pluck someone's DNA from a camera that is coming from a satellite in space. It is easy, trivial actually, and it's going to become even easier for governments and corporations to collect and store our biometrics like our iris, our face, our ears, the way that we walk, our gait, remotely and therefore en masse. Again, this concept of friction is really important. You can't have 1 million police officers collecting 300 million people's DNA. It's simply impractical. You can very easily in the kind of China-style surveillance system that we're seeing in certain regions of that country, set up camera networks that facilitate the mass tracking of people through their biometrics that are detectable remotely. So how is this happening? Again, we're not sure what's going on at the federal level. The FBI is very secretive. Congress has asked a lot of questions that have gone unanswered of the FBI. We aim to find out. We filed a public records request in January against the FBI and the Drug Enforcement Administration, asking them for information about how they use these technologies. We're particularly concerned about, in the absence of any regulation, the FBI using these technologies to track and monitor dissidents at protests and places like Standing Rock, climate, racial justice, anti-war, anti-Trump types of activists. And we do know, however, that the FBI has access to 640 million images of adults in the United States. So that's more, obviously, than every adult in the country. So essentially every single person with a state identification card, every person who's been arrested is in a database that's accessible to the FBI for facial surveillance purposes. That's pretty terrifying, and Congress has thus far done nothing to stop it. We also know that at the local level, like, for example, here in Massachusetts, the driver's license state ID database maintained by the Registry of Motor Vehicles is basically a perpetual lineup for law enforcement face surveillance searches. So we know that since 2006, state and local and federal law enforcement have been using that database to conduct maybe phishing expeditions, pulling images from Facebook when they want to identify someone and running it against the RMV's database using facial recognition technology to try to identify people. That's been happening without any judicial oversight, with no legislative authorization, no probable cause or even reasonable suspicion is required by police. They don't have to demonstrate that anybody's involved in a crime before they can perform one of these searches. And so we're very concerned that in the absence of any oversight or accountability at the state level, these systems are being abused and misused currently.
Yeah, I mean, anytime when I'm hearing about any policy and someone presents a very black and white view, my instinct is to be skeptical of that, because like with most things, there are sort of things on both sides of the ledger. So if we step back for a moment from the legality, I could imagine that on the one hand, this is technology that can be used to not only invade people's privacy in cases when they actually haven't done anything wrong, but also misidentify people. It might disproportionately be inaccurate with people from certain races, gender. I mean, who knows, right? There's all sorts of things on the bad side of the ledger. On the other hand, there are probably some ways in which this technology can lead to speedier resolution of a crime or more quickly finding a potential a violent person or whatever. It's all hypothetical. But then we get to what you're talking about, which is this seems to go beyond some of the basic tenets of how law enforcement is supposed to operate based on the rules that have been established with regard to warrants and probable cause and how investigations have to be done. And that's where I feel like the concern goes beyond merely evaluating whether the ends are worthwhile.
Yeah, I mean, in my view, there are three distinct ways that this technology can be used. One is to, as I said before, perform an identification of someone. So say there's a dead person, right? Law enforcement finds somebody dead in a ditch. They don't know who this person is. They're not carrying any identification. They run the fingerprints. The person's never been arrested. They're not, identifiable that way. Facial recognition could be a valuable tool in that case, right? You take a picture of the person's face, you run it against a database like the Registry of Motor Vehicles to try to find out who is this dead body. There's a second way that the technology can be used, which is vastly different, which is to supercharge effectively all of the surveillance camera networks that exist in our cities and towns across the United States with automation technology that makes it possible to, in the future, the technology is not really there yet. It doesn't quite work, but it will get better. And in the future, the technology may enable government agencies to type in your name, David Pakman, hit enter, and then automatically the software will stitch together a video showing every single place you've been over the past 5-10 years, however long the video is stored, who you were with, what you were doing, and prepare a nice little report. David Pakman was seen outside the cannabis shop on this date. He was seen outside the Planned Parenthood on this date. He was seen at a mosque on this date. He was seen at a protest on this date. He was seen with a whistleblower on this date, right? So that type of surveillance is the stuff that we're actually the most concerned about, and we think has no place in a democratic society. That is actually something that should just be banned permanently. We should never allow government agencies to create architectures of surveillance that facilitate that kind of mass tracking of people in public space. It has no place in a free society. There's a third way, which is also very scary, which is facial analysis technology. So this is technology that purports to be able to discern whether someone is happy or sad or anxious or stressed by evaluating their face. Now, a lot of it's junk science. A really important research paper was published by scholars at Northeastern University, including Dr. Lisa Barrett, who's a world-renowned psychologist. She reviewed over 2,000 papers in this area and found essentially that due to cultural differences, people with autism, et cetera, people depending on the moods that they're in and different contexts, it is actually not possible to discern how someone is feeling by evaluating the physical characteristics of their face. So we are very concerned that law enforcement, other government agencies will start to adopt technologies that purport to be able to tell police officers, potentially in a very high stress, dangerous situation, whether the person that they're looking at is stressed, has a criminal record, and may be armed and dangerous. And if the technology gets stuff wrong in that kind of context, which we assume it will, because technology frequently gets things wrong, that could mean the difference between life and death for a human being walking on the streets of an American city. And so we want to make sure, again, that those types of facial analysis tools that are already in relatively widespread use in the commercial sector. So, for example, in remote job interviews, they're doing these they're using these technologies over technologies like Skype when you're applying for a job at a large corporation. We want to make sure that government agencies are not using those technologies to evaluate, for example, in the interrogation room, whether someone's telling the truth or not when they're talking to the police. So there are two categories of the technology that we actually think should never be adopted in a free society. The other, we have an image of someone's face and we want to identify this person. I think that, for example, with dead people, potentially with Alzheimer's patients, and potentially in very, very, specific criminal investigations where there's a really high risk to the public, like, for example, in a murder investigation, with the appropriate level of judicial oversight and transparency and, rigorous auditing and public oversight, that type of surveillance may have a place in the 21st century. But there are some forms, again, that really just shouldn't. And we have the power, again, in a democracy to draw that line and say, you know what? Amazon and Jeff Bezos have a certain idea of what the future ought to look like. We have a different one, and we're going to make sure that ours wins out.
We've been speaking with Kade Crockford, who's the director of the Technology for Liberty program at the ACLU of Massachusetts. Kade, thanks so much for talking to us about this today.
I appreciate it. Thanks a lot.